In the latest C. Right past half from the XRP lawsuit between Ripple and the U.S. Securities and Exchange Commission, the agency has filed its Remedies reply brief under seal, signaling a significant advance in the case's remedies phase. This stage focuses on determining the potential sanctions that the fintech company might face if the SEC is successful in proving its allegations that Ripple conducted unauthorized securities transactions involving its XRP cryptocurrency. And it was always at the press. James K. Phelan, a former defense lawyer closely monitoring the case, updated the XRP community via X, formerly Twitter, stating the SEC has filed under side a brief and supporting exhibits. These documents are not yet public. Public redacted versions will be filed by Wednesday, May 8th, 2024. Other sealing-related filings will follow. Second, related data to scan. This filing is a crucial procedural step in the ongoing litigation, initiating a series of legal maneuvers centered around the confidentiality and disclosure of sensitive materials. Following yesterday's sealed T-filing, Ripple and the SEC will meet today, May 7th, to discuss and determine the necessary redactions to the reply brief and related documents involving both parties and any third parties. This session aims to determine what information remains under seal and what will be made accessible to the public. Tomorrow on May 8th, the SEC is scheduled to release a public redacted version of the reply brief, along with any supporting exhibits not designated as confidential or highly confidential under the current protective order. This release will only include those provisional redactions requested during the May 7th meet and confer. And further sealing motions are planned for May 13th, where all involved parties and third parties will file omnibus letter motions to seal all materials related to the remedies-related briefing, which includes briefs, declarations, and supporting exhibits, followed by the submission of proposed redactions to these materials. On May 20th, oppositions to the May 13th sealing motions are due. The process stipulates that parties are also required to file public redacted versions of all documents within the 14 days following corporate's decisions on the omnibus sealing motions. And the stakes are notably high, with the SEC seeking fines and penalties totaling more than $2 billion. Ripple's counterproposal suggests a maximum penalty of just $10 million, and the fintech firm argues against the SEC's proposed injunction, maintaining that it has instituted significant changes to avert future infractions. And Ripple's opposition to the SEC's demand for disgorgement is based on the claim that the regulator has not substantiated that Ripple's activities caused monetary losses to institutional investors. Regarding civil penalties, Ripple calls for a substantial reduction, arguing that the SEC's demands are disproportionate compared to penalties imposed in similar cases. Currently, a critical battle is unfolding over the testimony of expert witness Andrea Fox. Ripple disputes the SEC's characterization of Fox's expert declaration. Ripple's objection suggests that the SEC's bank categorization of the testimony is flawed. And Jeremy Hogan, a legal expert from the XRP community, commented recently on the matter via 10, saying, "I think the sound section will win this motion." He noted that, based on past case outcomes, court is likely to recognize Fox as an expert, thus permitting Ripple to depose her rather than striking her testimony from the record. At press time, XRP traded at $0.53761.